Okay, and so if sometimes I'm shifting around paragraphs, so I'll cut it out here, paste it there, it automatically renumbers all the paragraphs. Never have to worry about the order. It's really a writer's dream, actually. Okay, well, continuing on with this, that's the caption. Now, after the caption, you have the cause of action. Okay, so you specify the form, which in this case would be a court of record, and you identify the parties and their capacities if known. So, now what we're looking at right now is what I call the declaration template. But here's a sample declaration that we've got. Right. Everybody can read that, I hope. Can you see that okay from the back? Okay, so here we have a case, and this is modeled after a real case. And there's Complainer Doe, also known as People of the State of California. When we sued, my whole position, until shown otherwise, is that there's nothing wrong with the state. I own it. It's mine. The only problem I'm having is that the people that I have indirectly hired are not doing the job that I've hired them for. Okay, they're abusing their discretion and this type of thing. So I have no beef against the state. My beef is against these individuals. So I'll sue the individuals and hope that they will that the state will come in and say, wait a minute, these guys were doing their jobs, you should be suing me, not them. Now I can bypass the Court of Claims, you see, and say thank you very much. You know, I always want a deep pocket if I can find one.
Bypass to the Court of Claims?
No, bypass the Court of Claims. See, the Court of Claims is who you go through to initially. But when you already have a lawsuit in action and they step in and say, hey, we're the defendant, not these guys, so be it. Okay? Also, what you want is a policymaker in there. You've got to have somebody who comes back and maybe in his answer he'll say that it wasn't me, that I was just doing my job and that this is the policy. Thank you very much. Now you can add the state as a defendant. The state waives its Court of Claims procedure when it volunteers to be a defendant. And if this, you see, and if this person, I mean, all the Court of Claims is a 60-day delay anyway. You know, that's really how it is.
So an agent or an officer that's acting as for an agency of the state can invoke the state then? In other words, by saying I was just doing my job?
Well, if he's a policymaker, sure. And judges are policymakers. Okay? Absolutely. Yeah, they're management. Now, you know, the worker bee, you know, the guy who's going out digging holes, he doesn't make policy. You know, and if he screws up, that doesn't mean the state's responsible. They tell him what his job is. If he does something else, you know, you can't watch your employees all the time. But when you have the policymaker up there saying, hey, this is how we do things, well, thank you very much. Now the state's involved. And we have that situation in Aurora's case. Because when they did their demurs, they said the only reason we did not modify the suit is because we didn't want to extend it. We already got $20 million, okay? And we're already set up now because we knew in advance that all these guys are going to ignore us. They're not, you know, they're going to play their power position. So, but now we're set up where we've got them now. We're headed for the federal courts because the whole system is not responsive to law. So, and I expect that, and then if you read the Constitution of the United States, the Constitution says that whenever the state is a party, the Supreme Court of the United States is a court of original jurisdiction. Okay? So original jurisdiction means trial court. It's a court by right, not by privilege. See, appeal to the Supreme Court is a privilege. They can turn that down, but they can't turn down a case that's filed. Well, let's put it this way, they shouldn't. You know, the Constitution says that's the court to be in. So, you know, you look at the California Vehicle Code, it tells you right in there. They have a section which says that if you accept a license under the terms of the code, then you agree to the local courts hearing the cases. A little fancier word, but that's what they say. Okay? That's how they avoid the Supreme Court. Because you contract to go into a local court. Anyway, so I suspect Aurora's case is going to be ultimately in the Supreme Court of the United States with California as the defendant, along with all those other clowns that thought they were having fun. Well, okay, now this is a sample case. It's verified, all right? Now, here's the key thing right here.
Excuse me, Mr. Bell.
Yes.
It sounds, when you deliver the statement, it sounds so easy, huh? But I would like to make clear to everyone that it's hard, sir. It's too much to tackle. But if you're not aligned to yourself, to the truth that you would like to come out, that you're just so pissed off, and so I don't want to be, sounds like one here, but I wish I could deliberately say those words, but it's just that I cannot really say those words.
Well,
but I'm pissed off. But I'm saying it's just not easy, sir. It just take you the way you act because you have this belief. And
well, Aurora, I suspect that most of the people here have been in jail at one time or another, and we all know the frustration and the energy it takes to put together a lawsuit. No question about it. You're absolutely right. It's hard to keep your energy up. It's hard to keep the proper attitude and so on.
The only way I make it so simple is if I separate my body to my head, and then I could do my due diligence 100%. I don't even have the feeling. All I know is the truth. That's why my application is all my intelligence. But I have to separate from my neck down to my neck up. And that's the only way I could function.
Right. Yeah, you do have to develop that remoteness to your own case. You know, it's tough to keep an even keel. And when you write your papers, it's good to give it to someone else, some friend to read it, because they will detect that involvement you have. A person who's not involved can critique your papers. Even if they're wrong, you should still have them critique it, because it may trigger your thinking or set you back. It's our nature that we have to have feedback on who and what we are and our writings. And I'll write things sometimes. I'll write something, I'll spend a day writing something, and I'll put it away for 2 or 3 days and come back and read it. And I make all kinds of changes as a result of that. And because now I'm reading somebody else's writing, that's the way it seems. It's a good technique. So you do have to get that psychological separation that if you're too close to your case, it affects how you do things. Anyway, here's what you do. When you set up your lawsuit, you just say simple words. You say, like Robert Anderson, right, here and after Robert, is one of the people of California and in this court of record complains of. Right there, you have thrown in the bombshell. Okay? When you say you're one of the people of California, that automatically means you're sovereign. You don't have to say you're sovereign. You are sovereign. Okay? Where did I get the word people from? One of the people of California. I got it straight out of the preamble of the Constitution. The highest authority. Yeah, we the people. The word people is plural or singular. Works either way. It's correct to say that I am a people. Okay? You are a people. All of you are people. Okay? It's plural or singular. The word people is not the plural of the word person. The plural of the word person is persons with an S. Okay? So, I'm one of the people, or I am a people. Okay? In this case, remember this. What's the purpose? The number one purpose of a court. Anybody remember? That's exactly right, to put on a show. So, when I write this, I'm writing this for the long ears, not the long hairs. Okay? So I'm writing this for the ignorant opposition. And I know they're ignorant. They go to school, they learn all kinds of procedure, but they don't understand the system. Okay? And so I write this so that I slide things by them. And this is a great one. You just say, I'm one of the people of California. The guy reads this, yeah, okay, one of the people, right? Moves on. There's no significance of that to the attorneys. And in this court of record complain of? Well, everybody knows that these are courts of record. They all keep a record. In fact, if you look up in Black's Law Dictionary, 5th edition, it says right there, a court of record keeps a record of the proceedings and has the power to fine or jail for contempt. It says that, I think, in the 6th and 7th editions, too. I don't know, maybe the 8th. Okay? But if you look at the 4th edition, it says that, too. But it also says 3 more things. And one of the things it says is that it's proceeding according to the common law, which you know automatically throws out all the statutes. And it says that the tribunal is independent of the magistrate. And it also says in the penal code that all judges are magistrates. Okay? So no judge is allowed to make a decision in a court of record. So right there in that simple statement, I've suspended the judge, I've established my sovereignty, and they don't even know it. And I'm fine. I'm comfortable with that. You know, I mean, it is not my responsibility to educate them about law. After all, they all claim they are attorneys at law. They're all bragging that they know common law. Secretly, I know they only know equity and statutes. But they make a claim. Who am I to challenge them? I'm not there to quality control the lawyers. Yes, ma'am.
Mr. Bill, during the time I was telling you guys I would like to apply for pauper, and then they said again that the 1368 I'm incompetent. Remember that?
Well, Penal Code 1368 deals with
1370, yeah, 1370 in them paperwork, which is incompetence to stand in trial. But during the time, I would like to apply for my being a pauper, so I could go ahead and say, I didn't know the meaning of between the juris and the pauper. But guess what? That day, when I keep asking them, I wish to be released at the same time after I, deny I don't want to be a pauper. And she said, she's a lady judge, she said, well, I cannot release you now, but I didn't know how to ask why, what holds you up, so I didn't ask that. But then I found that out that it didn't come through because I brought it up, there's a conflict of interest here. I found there is a claim on this charge.
Sure.
So you have to really know what's going on and be aware,
well, you have to know what's going on. That is true.
Yeah.
But on the other hand, you can't know what's going on. Nobody knows everything. And it isn't always possible, especially when you're incarcerated. It's not always possible for you to keep your wits about you. I mean, it's tough to be in jail.
Mr. Magistrate, sorry to interrupt.
Excuse me. You can't talk yet. You're gonna address me that way.
There you go.
As the representative of a number of sovereigns here, I've been.
Now, what is it you wanted to say?
As a representative of a number of sovereigns here, I request a motion of the court to take a break.
All right.
Granted.
A motion to adjourn is always in order.
Point of personal privilege. All right. Well, now I guess we were talking about the commencement here. And basically, the commencement, you identify the parties and the forum. What we say here in the first cause of action, Robert Melvin Anderson, here and after Robert, is one of the people of California and in this court of record complains of. So right there, by stating he's one of the people of the jurisdiction, in this case California, he in accordance with the preamble of the Constitution, he's established his sovereignty. Right? The people ordained and established the Constitution for the United States of America, or they established it for California, whatever it says. So that gives you the sovereignty, and you don't have to brag about it. You just say it nice and quietly. And the court of record, that's all defined. And the key things here that we're interested in is the fact that the court of record is prohibits the judge from making any decisions, because the judge is a magistrate and the tribunal has to be independent of the magistrate. And who's the tribunal? Well, it's the king, or the jury of kings.